দাদা আছে নাম?
I appear for the appellant writ petition. I made just a আছে ওখানে এখানে উপরে একটা
উপরে আছে।
I made a 3-page basic dates. Lordship may kindly take that.
So final hearing, Mr.
It is for final hearing, but no, there is an order that all papers are there excepting one document which was handed over, so it was not brought as one of the documents. So there is the direction for that, to that effect. Well, I don't think, well, this is, I'm essentially seeking an identical order being passed by the honorable division bench, not once, two different honorable division benches. So only bone of contention is whether my case is covered by the said division bench or not. I am protected. There is an order by the honorable division bench also, and the land is still there.
Why don't you prepare a paper book and come?
There is no necessity because there is already an order. This question came. Lordship, may kindly have a look at. I am showing the order itself. Otherwise, I would not have. Order kindly take the order dated 26th of
হ্যাঁ, এগুলো অ্যাপ্লিকেশন হিসেবে রাখা হয়েছে। এই বলেছে ইনসিস্ট করেছে আমরা
order dated 26th of April, page 2, top.
এই কার্তিক কিন্তু সময় কিছু আছে
এটা আমাদের আগের অর্ডার।
Twenty-four.
Page?
Second page. Or Lordship may see the first page from the last para.
20, it is not in the year. Oh, 26th
Of April 24. May I read it out short?
26th April.
26th of April 2024.
26th. Yes.
May I just, last paragraph, first page. We need to hear out this appeal. No useful purpose will be served by having multiple hearings. We are told that all the papers that were available before the learned single judge have been annexed to the applications filed in this appeal, excepting one document. Such document may be filed at the time of hearing. We will treat this stay application as an informal paper book. All formalities, and thereafter, 3 questions were, Lordship may kindly have a look at the order, next order on 3rd of May 24.
Give us a moment. What a problem. 6 years ahead. Even goes decision in possession. Lottie.
I was the original allotee.
Oh, you were the original
Yes.
allot.
Yes.
Now,
So that is the difference. In
no,
the,
no, let us
sorry.
understand. You were the original allot.
Yes.
Land was allotted in 1989.
Yes.
Now you paid the installments. In one installment, there was a delay of 6 years.
6 years. Correct.
However, it was
I
accepted.
paid with interest also. They accepted it.
Very good.
They
Now,
accepted it for a period of 1 year, approximately 7 months. Then I made a letter seeking possession.
of the allotment made in 89.
Yes.
Hmm.
Once I sought the possession, they gave me the impugn letter. And the impugn letter subject is termination, but the body of the letter is we are returning your money. In the
That was in the year
uh, that was in the year 2000 exact. I'm giving one.
মানে এই
Well, 2001. Well, this Lordship may kindly take that 3-page.
just says there was a huge delay of 6 years on but after 6 years money was received but not accepted. Upon huge delay, আচ্ছা কি বলতে whether notification is still operating the unsolicited being our practice content এই পলিসিটি 8th অক্টোবর যেটা অ্যাপ্লাই করলো allotment তো 89 এ
Yes. Yes. Lordship, kindly take the, I have given a 3-page short dates so that Lordship would not be required to go into any of the documents.
তাহলে বলবে সব কনসিডার না করে অর্ডার দিন
No, no. Because I said, my lord, the bone of contention is this. Because, my lord, as far as the facts, I would hope that there would be no difficulty on any of us on the facts.
No, we have land. We have
Yes.
lot of land. What we have.
You have.
yes
It's a plot of land.
It's a plot of land.
Have you, in this delay of 6 years, did the government allotted to somebody?
No,
No,
till
Lordship,
today.
I may just clarify this. No, I have not. We have
No,
not.
till today. There was
Because
an order.
there is a-
Here you sit down.
Achha, very
There was an order since 13 and also the division majority. It's there. Lordship, kindly take first. It was in 26th of December 89. This allotment was made. Then it was accepted also in January 90. My lord, there are 3 conditions. If Lordship kindly take, the first condition was 10% of salami to be paid. I paid in time. No dispute on that. Second condition was 1/3 of the salami to be paid within 2 months. I paid, no dispute on that. The third condition was the rest amount. Lordship may take note. The first condition amount I have not mentioned, it is 805. No dispute, 805 I paid. Second condition was 1,878. No dispute, I paid within time. Third condition was rest amount. Rest was 5,000.
170
Sorry, my lord.
1878
1878. That's the second. Now, third, which is I defaulted, that amount was 5,365. I was supposed to pay it by 1993. Admittedly, I did not pay by 1993, but admittedly, I paid it on 14th of June 99. That is after a lapse of 6 years. Now, while I paid, I was supposed to pay 5,365
Put in the interest as well.
interest because 5% there is a clause for that. I put and they accepted. There is a letter of acceptance of that. Then, my lord, after this all payments, then I wanted that, then I will make a construction. So I need to get the official possession of it. So 11th of April 2000, I made the possession. I sought the possession. Well, there once I made this possession letter, that was on 11th of April 2000. So thereafter, my lord, on 15th of January 2001, it's after 1 year, 7 months gap from the date of receiving the amount. they issued a letter, which is, if Lordship may look at the letter, page 101, which was impugned. Lordship may first kindly see the subject. Termination order in respect of plot number such and such at Kollani. Sorry. Okay, sorry. No, 101. Lordship may kindly see the apparent contrast. The subject is termination order in respect of the plot number such and such. Now kindly see the body of the letter. Whereas you have violated clause 3 of lease agreement dated such and such and became defaulter for non-payment of 3 consecutive installments. And whereas the pay order number such and such dated such and such for rupees 7,832 has not been accepted by this department, the above pay order is returned herewith. So,
Now, what is clause 3?
yes, clause 3, my lord, page 97. Okay. Page 97 is it. Clause 3, my lord, it contains that there are 3 situations that I have to pay and within what time I have to pay. And if I don't pay, then there is a clause that Lordship, may I kindly take clause 3? Lordship has got clause 3 at page 100, page 97. It starts with that we shall pay at least 1/3 of the premium or salami in respect of the said plot, inclusive. Now, this first entire paragraph is not relevant for the purpose of determination or termination of this lease. Second paragraph is relevant. I shall pay interest at the rate of 6% per annum from the date of acceptance on such a premium or salami or any part thereof, which may be allowed by you to remain outstanding in respect of the said plot, and interest will be the first charge on the deposited amount, and the said amount so remaining outstanding will form a first mortgage and charge on the demised land and the building or building as may be erected thereon. The balance of premium or salami so remaining outstanding together with interest due thereon in respect of the said plot shall be paid by me in 3 equal annual installments. The first of such payment to be made within 1 year from the date of acceptance of the offer, which I have said it was done within time. And the subsequent 2 installments together with interest payable in 2 successive years should be made. No, there is a full stop. Successive years. So it means that it has to be made within that time, successive 2, out of which 1 I paid in time. Should we made default in payment of 3 such installments, this is the relevant portion. Should we?
So your contention is you have not violated this clause.
I say that there is a notification by the government which says if there is this kind of violation, then there is a provision you have to pay a lot. For an example, notification requires me for such violations.
No. Is it your contention that clause 3 was not fulfilled by you?
I think there is a violation by me of clause 3 in some sense.
Very
I
good.
can't.
How did you then? Let us see what is the reasoning given.
Reasoning is there is no
One
reason.
as
Reasoning
per
not.
clause 3 you have violated, so we are giving you the back.
That's all. It's not a termination. Reason that part I will come. The reasoning is Lordship will not find the reasoning at all because that letter is.
Come to the proviso at clause 3 of page 97.
Yes. Provided, however, that 5%. Yes, I mean,
It says shall,
yes, yes,
government shall.
yes,
Please,
yes. Provided, however, that should we pay the annual installments of the balance of premium or salary payable by me us with the interest payable thereon duly and punctually by the government shall accept, well, I am deeply obliged, interest on the said balance of premium or salary at the rate of 5% per annum in lieu of 6% per annum. We may pay more than one installment of the outstanding price. In case of short payment, well, that's, well, I'm deeply obliged. I missed that shall. I missed that. Now this shall has,
notification যাবার দরকার নেই।
I missed it. I missed that. Yes. Now this shall has been translated in the form of a notification by saying if there is any kind of deviation.
Or
Sorry.
if you're covered by the proviso,
Yes.
why do you want to rely on the notification at all?
Well, I would be extremely happy, but I mean, I would be happiest. I would be happiest. Sorry.
Salami payable by us with the interest payable there and punctually. Actually পড়ে থাকে তাহলে দেবে গভর্নমেন্ট
Interest. তারপরে shall accept interest on the set balance of premium or salary, the rate of 5%. যদি পাংচুয়ালি পে করে তাহলে তো ইন্টারেস্টের প্রশ্ন আসবে না।
ক্লজ 9 তে দেখো ক্লজ 9 এর ভায়োলেশন হলে টার্মিনেট করতে পারবে ক্লজ থেকে। এখানে কোথাও নেই। Yes.
Now, well, there is a notification was brought in by the state that if a person who has failed to pay or there is a violations, then he has to pay much higher amount of money.
Hmm.
Now, much means like for non-payment of 5,000, now I have to pay about 16 lakhs. Yes. Now I have no difficulty to that because that bone of contention is they are not saying they are not giving, they are not willing to give it to me. They are saying not 16 lakhs, you have to pay 59 lakhs, which is the fresh lease agreement market value between two private parties. That's the core bone of intention. They offered me before the learned single bench also. I say, how can it be? Because the honorable division bench mentioned. Yes,
Then
sorry.
what do you want to show us?
Yes, Mala, I want to straightway, if Lordship kindly come to page 155, the judgment by the honorable division bench. And I said in that judgment, it was not even an original allotee. It was a person who got it illegally for the original allotee, and the original allotee never challenged. So to say that it is a different case, yes, but that's a positive difference, something in my favor. Madam, may I place it? The appellant was the writ petitioner before the learned single judge.
Tell us in a nutshell.
Yes, may I say?
The notification was relied upon page 150.
Yes, this is the notification which was relied on this page.
Very good. Then what did the
And
according
there is another honorable division bench judgment also. Well, this is at page 151. But that is an earlier division bench, but this is,
so this in this accordingly appellant shall be at liberty to pay the requisite amount to the government.
yes.
What is the requisite amount?
Requisite amount is, Lordship may kindly see that page,
So that he's
I'm
that
cutting.
if
Huh?
the appellant pays salary.
page 156, last paragraph, the last two lines, mentioned by the honorable division bench.
As per the 8th
Yes,
October.
yes. But that's the entire issue.
Or any other subsequent notification.
Yes, if there is, that's the reason 3 questions have been asked by the honorable division bench, and they said state it is holding the field.
So what is their reply?
Their reply is this notification of 10 is holding the field.
Still holding the.
Yes,
So show us that notification.
yes. This is page 165.
Page 165.
Yes.
What is it?
D.
How many kathas?
Yes, I'm saying that. Kindly come to D for me. D Roman 3, 8 kathas. So it is 2 lakhs. So therefore, I said 8 into 2, 16 lakhs.
Where you are saying?
I say at page 165.
Individual above 5 katha.
Yes,
So yours is 8 katha.
8 kathas. So
So 2
in case
lakhs.
in case of the judgment of the Honorable Division Bench in Mira's case, it was within 5 lakhs. So it was 1,50,000. So my case has to be Roman 3, 2 lakhs per katha. So for D,
No, in that case, Mira's case, was any letter of termination issued?
that's the point. Kindly come to Mira's case. Kindly see even, before reading it, in Mira's case, the difference between Mira, I say that there is a difference, but that's a positive in my favor. Why I say it is a positive in my
So we
favor?
understood. Now, what do you want to say? Mira, was there any termination in Mira?
Yes,
Where is that?
yes,
Is that perimeteria with your termination?
yes.
Show us the termination.
Lordship, that's the, kindly come to
Stated
page
in the order,
156,
na?
page 156. Second paragraph. The learned single judge noted that Bhatto Krishna paid only 1/3 of the salami. In my case, in Mira's case was a difficult case.
We lost in fulfillment of 9 of the target. 9 is total আমি দেখছি।
156, kindly see second paragraph.
কত পেজ বলতে পারি? লিস্টটা কোথায় গেল?
Which was the, can you tell us the page of that lease, Mr. Bharat?
97.
No,
No, no. হ্যাঁ
হ্যাঁ।
Anyway, এনে মনে হচ্ছে
From the originality. Sorry.
Bhatto Krishna original.
Sorry. I stand corrected. Bhatto Krishna was the originality, but the writ petitioner was, sorry. In respect of the plot land that was allotted in his favor, he failed to pay the balance salami. So out of 3, there was 1 payment. Unlike my case, out of 3, 2 perfectly fine, 1 delayed of 6 years, paid including interest. That's the difference. Resultantly, the lease agreement was terminated by a written document dated such and such. This was your lordship query. Such termination was never even challenged by Bhatto Krishna. And here, the original allottee challenged. The learned judge held that since this lease to terminated in 74, Bhatto Krishna had no right, title, or interest in the concert plot, which he could transfer to the writ petitioner. Accordingly, the learned judge upheld the authority's order impugned before him and dismissed the writ petition, hence this appeal. On the last occasion, we had requested Mr. Sengupta, learned advocate appearing for the state, to obtain instruction as to whether there is any scheme of the government which could permit regularizations of the property in question in the name of the appellant. Mr. Sengupta has apprised us today that his definite instructions are that if the appellant pays the salami transfer fee in respect of the plot in question in terms of, this is 8th October 2010, and they have accepted, I have that document also, or any other subsequent notifications in the regard, the government shall execute a fresh lease in favor of the appellant. Learned advocate for the appellant on instruction says that appellant is prepared to pay such amount. Now, I am absolutely, now, while delivering judgment, in my understanding, the learned single judge.
Go before Justice Banerjee.
No, please, my lord, my lord, ultimately the gentleman.
My lord has said the question. You go to.
Well, that kindly, my lord. This gentleman now, he died in 18. Thereafter, a substitutions.
No,
only the widow and the.
No, Justice Banerjee said that I am calling for 3 questions. I will decide.
And answer us there, and this is a quiz contest kind of questions. Nothing to no, lordship are not required to enter into no philosophy in it. Nothing depth in. Yes or no answer.
Go to Justice.
Kindly, my lord. Kindly. My lord, then what will happen? Kindly, my lord, I would be requesting your lordships. And there are other division bench. There is Supreme Court also that you pay the interest.
We will observe.
My lord, that. My lordship may keep it. My lord, I won't be able to make an assignment letter. But if lordship
will agree. He will agree.
No,
to
he's
such
my lord, this.
You file a joint assignment letter to the chief. It will be sent to Justice.
My lord, Justice Banerjee is also. I know lordships is also. Lordship may keep it on another day, on a free day. I have no difficulty. Kindly, my lord. I don't want to go anywhere else. But I don't want to go. My lord.
Why? You don't want to go?
If lordship forces me, I have to. But lordship keep it on another day if lordship feels like. But I don't think it is a heavy matter at all.
We don't want to embarrass anybody. Suppose Justice Banerjee has taken a line of thinking.
Yes.
If we intervene and we don't know, we have not heard him, whether we will take.
But there is an every likelihood. If lordship feels that lordship is going to take a different, then
that is wastage of time now, Mr. Dhar. We will listen to you. We will find we are not agreeing with.
But there is, all I'm saying is this: there is no bar. We understand.
No, I'm not on determination.
But I'm not a bar. I could have understood that there are cases which are really intricate question of law. This is not that kind of case. Genuinely, otherwise I would not have said. Had it been a case that really lot of efforts are necessary and lot of nuances are there, I can understand. This is probably a kind of, in my. Well, I would be requesting. Lordship may keep it on another day. Both of on this there is no dispute.
The assignment. Ismail, agree to the assignment letter.
I was generally do not agree with Mr. Dhar. I do not agree with Mr. Dhar.
Okay,
but
I
to some
did not
extent I am agreeable. More particularly to that extent that lordship should hear out this one.
That is fair, good data.
No, we don't understand why you are not going to judge.
No, I have no objection.
Because his lordship is taking criminal matters.
That cannot be a ground for us, Millet, to
Exactly.
because they have already enjoying an interim order.
Well, may I?
Since
That is passed by Justice Banerjee.
no, it was going on since Miller, the writ petition was instituted.
No, that is by
No,
Justice
that
Banerjee.
is
Yes,
by
yes. After
Banerjee.
that, Justice Banerjee has passed an order. That's
No,
true.
we will record that.
Well, may I say?
Record that
May,
and send it.
well, may I
Status
say
quo has
this?
been till the
Well,
disposal of the
there
applicant.
is a.
Right.
May I say this, my lord? There are thousands and thousands of matters. Now, making a letter before the Honorable Chief Justice, I can understand, my lord, really, this is that kind of matter. Genuinely, your lordship feels that this is such a matter that there is a so much of different
For
point
that,
of law.
Not for that, Mr. Dhar. There has been an exercise of discretion by the court.
Yes.
Court has said that prima facie there is similarity. Let me know whether that government notification is operating or
True.
not. That is why the question.
And they have answered saying
So
their
today,
answer is yes, it is operative. That's the
if
only
they
answer.
have answered
Whether that is
operative,
applicable to or
then
not.
his lordship will take the view whether the earlier view will be accepted. That is also of his lordship. Or would his lordship take any different view in this?
My lord, we would be
So
extremely
both-
happy.
Both ends up, it will go
My
to
lord,
justice. No,
either way, whether it is taken up by your lordships.
no, Mr. Dhar come with a better case before us.
My lord,
The
then
records reveal that the
HON'BLE. Item number 3.
May I submit?
Next Thursday করি।
But the amount which was about to be allotted me, that is the 33%. That is with the collector, ADM that they admitted that in affidavit in reply opposition.
What instruction we sought for?
My lord, there are three sets.
Whether it is with the DM or not.
DM or not, that is with the DM. They are admitted in their reply. Of opposition,
ঠিক আছে,
opposition.
He wants to come back with that instruction. It will be in the supplementary list, sir. Next Thursday করে দেবো। Yes, next.
But I have also been instructed to serve upon the private respondents. But I serve my affidavit of service kept with the record.
আচ্ছা লিখে দাও affidavit of service, as file, be kept on record. একটু ফাইলটা দাও তো।
তোমরা রিপ্লাইটা
আর মিস্টার ঘোষ, এটা ঘোষ তো না? হ্যাঁ, you are ঘোষ না?
My lord,
You are
he is my junior.
ঘোষ তো না?
My
What is your title?
my Siddhartha Sorkar.
হ্যাঁ,
Siddhartha Sorkar.
Heard Mr. Sarkar, learned advocate appearing for the appellants. Oh, আচ্ছা। So, heard the learned advocate appearing for the appellants. Learned advocate appearing for the state respondents. Prays for an accommodation. Mr. Ghosh,
Paragraph.
when he's, it is the question of instruction, let him come. And accept. Yes, next.
Your Lordship, I appear for the appellants. Your Lordship, I am seeking leave to file a supplementary affidavit and also make corrections.
লিস্টটা শুদ্ধ দিয়ে দিয়েছি তোমাকে, ফাইলে তুলে দিয়েছো আমার লিস্টটা শুদ্ধ
লিস্টটাও
হয়েছে।
চলে
আচ্ছা,
গেছে।
ঠিক আছে, ঠিক আছে। Yes,
There are
item
corrections
number 4.
for Your Lordship.
Eh.
There are corrections required in the stay application. Inherently, in the paragraph number 34, there are certain corrections and prayer portion of the stay application. Page 21.
There are defects.
Your Lordship, the order date and the honorable judge's name is incorrectly mentioned there. Not formal defects, defects which has not been pointed out by the department. Page 21, Your Lordship.
What do you want, madam?
Your Lordship, the stay application, paragraph number 35 has certain
We will consider what your filing supplementary to the
Supplementary.
stay.
Your Lordship.
You have given copies.
Your
to-
Lordship, we have served a copy.
দিয়েছো
হ্যাঁ,
এটা
হ্যাঁ।
yes well
So what you are wanting today?
Your Lordship, the corrections may be allowed to be carried out because
What
if
is the matter about?
the matter is pertaining to royalty. The respondent authorities have levied the royalty which is already paid by the petitioner. Petitioner has been paying the royalty and cess to the government. In excess to that, respondents have issued a notice increasing the quantum. For example, the petitioner had been using, as per the government notification, the quantum cannot be increased. Now, as the environmental laws are very strict, the government has themselves fixed a quantum. In excess to that, the quantum has been increased by the government on its own, and the excess price has been demanded by the respondent authorities. On a very short point, Your Lordship.
Writ petition is still pending.
Your Lordship, the interim order was denied, wherein,
What interim order you prayed for?
Your Lordship, we had prayed for no.
Place the order, place the order,
Your Lordship,
but you are not ready.
Your Lordship,
You are ready in the matter.
Your Lordship, in this, my learned senior Kollal Basu is leading me in this matter. Today, I may carry out the corrections and come back on the next date.
What correction you want?
Page number 21, Your Lordship. Paragraph number 35.
What?
Your Lordship,
Name of the judge has
the Honorable Judge's name, the order date, and the writ.
that we will do. There is no necessity for further order.
Your Lordship.
Let the supplementary affidavit filed by the learned advocate appearing for the
Item number 5. We have put the respondents.
This is affidavit in reply.
yeah. Yes.
A copy has been served to the other party on 18 as directed, and we were
They have used an affidavit.
affidavit in reply.
You have used reply. They have used an opposition.
Against the opposition, I have submitted affidavit in reply.
Where is that?
That I have submitted.
Oh, acha, acha, ঠিক আছে.
Copy also have been submitted to them as per directed on 18.
Very good. Yes.
Actually, problem cropped up when in 1996, when my name has been recommended by general manager for the post of deputy manager. One Vicky Pal has tampered the marks and make it 75 to 72 and eliminate my name from the promotion list, which I have annexed in the affidavit in reply at R1 and R2. And after that, when I challenge that my promotion is due, my promotion must be given, they have issued a charge sheet, tampering leave application, suppressing the report of the question documents director, West Bengal government CID, where he has given a clean cheat in favor that there is no tampering. If you want to see that report of question document, it's a lengthy document, so I have not submitted. If you want to see, your lordship, I can show you.
No, you tell us the facts. Then what happened?
After challenging, I challenged that charge sheet before Honorable Justice Altamas Kobir on 11096, and Altamas Kobir has given the order.
When was the order? Which order did you challenge in appeal?
Appeal I have challenged, one appeal I have challenged in 5th August 2003, there is an order. There is an order I have challenged.
Just a
Altamas Kobir, allow me to say, Altamas Kobir gave a verdict on 11096 that no order of inquiry will be passed without the leave of the court. But
Mr. Chakraborty, where is the order under appeal?
Those are not sought to me. Only one can application is with me. Memo of appeal আছে তোমার কাছে?
thereafter I have served affidavit in reply. Reply টা দেখুন।
Initially, there was a remove.
Did you challenge the order of 2nd August 2007 before the appeal court?
Before that, there is an order of Chief Justice Ashok Mathur Division Bench on 5th August 2003, when the order of removal was served in the court. And Justice Mathur said that once that order of removal was served on this court, you are in service from 5th September 2001 to 5th August 2003, when the order of removal was actually served. And before
Your
that,
appeal was disposed of, madam. The appeal which you preferred, that was disposed of by the appeal court.
no,
And you thereafter filed a contempt application. In course of contempt application, they made a payment of about 1 lakh towards full and final settlement.
no, Lordship, that's not the case.
So then come to the order of Justice Showman. You place the order. Don't say
Yes.
no. Don't say no. We are saying
So
from
that
the,
there is an order.
we are not on that, madam. This is a disposed of appeal. This is a disposed of appeal. In connection with the appeal, you filed 2 contempt applications.
No,
Certain orders were, before saying no, please listen to us. Before, in contempt application, certain orders were passed. Contempt was also disposed of. Then you,
thereafter the case was filed before the same judge, Justice Ashim Banerjee,
Yes,
when
yes.
the new cause of action arises after Ministry of Railways has taken
that was not accepted. Kindly come to Justice Showman's order.
before that I am to show you the order.
Madam, we have gone through your brief. You are filing, you are reinvigorating a claim which has already been settled.
No, Your Lordship. Showman Sen has said that you have told this is the Showman Sen's order.
You read, we have read it. You read and find out. Every sentence, if you say no, it is very difficult to.
Your Lordship, I am sorry. If I say
No, you
something-
please. We
I'm
have,
80 years.
madam, we have tried to extend all sorts of assistance to you. We have heard the matter thrice earlier. But you are insisting that some other payments is due to you.
That you have said in your order 11 December 2024.
Yes. So we called upon him that you please come and tell us that any further amount is due or not.
His salary is 23
He
months
said, no,
salary is due.
that has been adjudicated upon. It cannot be reopened.
see the order of so many.
We have seen the order, madam. We have seen the order. Have you read Justice Sen's order? Then why don't you take it up from her? You can argue.
I have not read, Lordship.
You have not read. So
Actually-
please assist her then.
Yes, Lordship.
Go through the.
I'm trying.
You are an. No. Let us explain to you. There was a writ court order against which she filed an appeal.
Yes, Lordship.
Now, appeal, certain directions were issued and appeal was
Disposed
disposed of. As the order was allegedly not complied, she filed contempt application.
Yes.
In contempt application, she received certain payment.
Yes.
No,
And the contempt application was also.
Not received.
I have not received anything, your lordship. All that.
You have received on 12th August.
All are mistaken. I have not
আপনি
received.
কন্টেম্পটে কিছু পাননি?
অল্প পেয়েছি।
অল্প পেয়েছি তো কি পেয়েছি?
New cause of action.
Madam, madam,
হ্যাঁ।
please sit with your sister. You explain everything to her so that we can explain the situation to her.
Your lordship.
Madam, we can
Your lordship,
act on.
kindly see your order on 11th December,
Yes.
wherein you have said that this matter was already heard by same judge on 27th June, CAN 10189. That was heard by Justice Oshin Banerjee. Can you see this? The same judge.
Disputing
When the
that.
new cause of action arises because of the undertaking by Ministry of Railways, the Ministry of Railways has already, before that, the Ministry of Heavy Industry was there. Thereafter, the Ministry of Railways has taken, they have completely changed the scale of pay. Kindly see this, the cause of action, this cause list. The same judge, Justice Oshin Banerjee, has heard the case. And Justice Somen Sen has quoted the order of Oshin Banerjee, nothing else.
Is an application of payment of ADR to 23 months. It was turned down by single judge of the position of disability. Apparently, approved simple mention.
And CAN 10189 also.
No abandonment in the act. Preparing the division bench, such and such personally following.
And you see this.
The doctor found one of their appearance. In view of the concession made, we dispose of the key. Appellant will be treated as written. The allegations with such and such can would be in all written with up to 5,000. She would, however, not be entitled to ADR from 5th September to 5th August. Second page. Yes. Your entire return is not paid, must be paid within 4 weeks. তিনি চাইছেন সেপ্টেম্বর 2000 এই পিরিয়ডটার জন্য আজ সেপ্টেম্বর 2001 থেকে that you have not been paid the salary for the period from September 2001 till August 2003.
Yes,
This was your grievance.
this 23 months.
This was now trial judge said that trial judge said that you cannot get that. If you want to claim that, go before the civil court. Please, if we have understand wrong. Now what you did, you challenged that order before the appeal court. Appeal court said that so far as that portion is concerned, we cannot do anything. However, you will be entitled to all the retiral benefits.
Thereafter, the same
Just a
judge
moment.
said,
Just a moment. Now that order was passed by the Honorable Justice Ashim Kumar Banerjee. So that order was allegedly not complied. You filed 2 contempt applications.
contempt
Yeah,
appeal for
just-
Provident Fund.
Acha, what do you? Yes, yes.
Statutory interest.
After the contempt application, dues were paid to you, but they still did not pay the amount from 2001 till 2003.
For that reason, I new
For
cause
that
of
reason,
action
you preferred an application.
application.
Now, Justice Sen said,
Not before that, same judge heard the case. Your Lordship, kindly see this. Can 10189. Can 10189 on 27th June, when the new cause of action arises out of undertaking by
what is come to 10189? 10189 prayer, you kindly come.
comes,
What is your prayer in that application, madam? Please come.
please, that was give me the salary, area salary,
Then,
area salary for 2 months.
so this prayer has already been refused.
No, that was not hard even. That was in Showmanship also said.
What was the application? Application was that pay me salary from 5th
From
September.
5th September to 2001. This is the application. Kindly see this.
This application, the prayer which you made, has already been considered.
Not considered. Was not considered.
Then we are unable to explain to you. We are going to dismiss your application.
No, don't.
Sorry, madam.
I'm 80 years. Don't do this, Your Lordship. Your Lordship, I'm 80 years. This is, yeah, and you kindly
Madam, we have given
see
you.
your order is
Madam,
in
we
December.
We have
sorry.
given you. We have gone through your papers. We have tried to say something that whether anything can be paid to you. Madam, we are helpless.
What, 11 December? What is your order? Kindly see your order.
Yes, we made an endeavor that we will call upon him that Mr. Chakraborty
see
sees
this.
something is payment.
10189 that
To read, can 10189 is a prayer for salary.
Showmanship's order also, it said that can 10189 was not heard. and
Yes,
this-
so it
and
has
she
been
was
placed before
prevented-
us.
she
It
was
has been
prevented-
placed before
Original
us.
record was called for, Lordship, in the Showmanship order, Lordship. Next date of hearing,
Yeah,
called the original record.
Listen, madam,
Yes, Lordship. Yes.
this is not a place where we understand her suffering. She is an aged lady.
Yes.
Is an aged lady.
Yes, Lordship.
But we cannot do something which we cannot do on records.
But see this, what is
Please, madam, please try to explain.
11 December, your order, your Lordship, you have considered. You have considered my.
আর কিছু করা যাবে না. We have tried our best.
No, your Lordship, this is not justice. I'm 80 years. Do justice to me. You have considered on 11 December. Now you are
11 December, what did I say? Come to the prayer.
see your
11
order. Your
December,
Lordship.
we said that please file an affidavit and to avail instruction as to whether anything is due and payable to you.
Is
Anything
due.
is due, Mr. Chakraborty.
According to railway, Milord, nothing is due because of all what is paid with interest.
Railway has no connection with this. This is about bond standard. Last time also, Shomo Majumdar appeared before Justice Talukdar on 12th June 2022, which I could not appear, and that was past 6 June 22, the Shomo Majumdar has appeared on behalf of bond standard. If there is no payer, why he appeared in the case? Case was continued from Showmanship Justice 2019. He was given the order, but lockdown was declared and order was not given. Thereafter, the case was heard.
Madam, you cannot get the salary from 2001 to 2003. It has been settled. If you still have any grievance, you have been asked to go to the civil court. Writ court cannot do anything.
Your
Please,
lordship
please, madam, try to understand.
is
Try
going
to
against your own order on 11 December. You have considered my
11
prayer.
December, 11 December, we asked him that you file an opposition. We condoned the delay and we directed
You
him.
order, you kindly see this Home Sales order. Home Sales order.
order দর্শক দেখেছি হ্যাঁ দেখেছি
Have you filed wakalatnama in the matter?
no I am not.
She
has vision problem, so I am here.
I lost my vision. I am 80 years. Consider my prayer.
Madam, we are releasing the matter. Go and tell the Chief Justice, if anything can.
Your lordship.
Madam, we cannot do anything.
You cannot go against the
Here-
Home Sales order.
We are not going against Showman's order. We are
Home
going.
Sales has quoted the order of Ashim Banerjee.
2 সপ্তাহ পরে রেখে দাও।
হ্যাঁ?
Come after 2 weeks. We are unable to convince you what can be done. Matter will remain pending. If you say I am 80 years old, you do something which I cannot do, what I will do? What will we do?
That Home Sales has ordered that appellant should
Explain that to her. Explain that to her.
একটু পড়ো না এটা।
আমি দেখেছি তো
Listen, you go through, madam, you sit with her, you go through the papers. Our understanding is that his writ petition was disposed of, rejecting that prayer, that you go to the civil court. Against that, she preferred appeal. In appeal, certain orders have been passed and she got the relief. What remains is the arrear salary from 2001 to 2000. This as regards the arrear salary, Justice Ashim Banerjee's order, after that it came up to Justice Sen. Justice Sen passed a detailed order, but as the 10189 application was not on record, his lordship said that bring that on record.
But
That
Justice
has
Home
been
said,
brought. We have considered that we cannot
How
give any benefit to her.
your lordship.
But if she cannot, if she does not want to, if she does not allow us to pass any order, we have no option but to adjourn it. If she says I am 80 years old, you do not dismiss my matter, then the matter will remain pending.
Showman Sen has accepted.
Then
my
go to Justice
contention.
Showman Sen.
Huh?
Then go to Justice Showman Sen.
Transfer my case to Showman Sen.
Again go to Justice Sen that it is because of your order I am not getting.
So transfer my case to Showman Sen.
Transfer my case.
We are releasing it. You go to Justice Sen. We are recording. You will make a prayer for assignment of the matter before the Honorable Justice Showman Sen, and we are releasing it. You have no objection if it is referred to Justice Sen?
I have no.
Your lordship said on 11 December. Now you said something else.
11 December order. Why you are uttering these things? Huh? What have we said? presentation to the Chief Justice Secretariat for assignment before Justice Sen, and that letter Mr. Chakraborty will also give consent. All right, Mr. Chakraborty?
We have no objection. If it is
Yes.
assigned,
চলো দেখে দাও আমার একটা বেঞ্চ আছে তো ও আছে ওই তো ইয়ে করতে গেল আর এই নবকুমার বেশি বলে দিই।
না 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 মাথা গরম নিছি
হ্যাঁ, এসছে ওটা।
matter may be permitted to
Last order.
be assigned matter. Matter may be permitted mentioned on matter. Matter this matter was heard by your lordship on 27th February, and it was stated heard in part and was fixed on this day 2 p.m. today.
Sir, what can we do? The bench has changed.
If your lordship, my lord, why I'm mentioning
We will give the slip. It will appear in the list. Thereafter, because I would not be regularly sitting with my brother.
Whenever you.
your lordship kindly fix a date because we are
I cannot
suffering.
fix it today. Let it appear along.
My lord, my lord,
When
my
we will sit with my brother, it will appear in the list, and either it will be taken up by us or we will release the part.
No, my lord, please, your lordship is not. Your lordship kindly.
Your lordship heard the matter.
Kindly, don't release it, right?
লিস্টে দিয়ে দিও তাহলে।
Deeply obliged.
Yes.
In the meantime, they are giving permission, breaking all superseding us. And
What can we do, sir?
without following the norms and which are fixed in their meeting.
All right.
And another thing is this,
We will keep it in the list.
my lord, I'm grateful to you.
Yes, Daku.
Lordship, I'm only mentioning for rectification in the name of the respondent, Your Lordship. This order was passed on 11th December 2024, Your Lordship.
কি বলছে? কি অর্ডার দেখি? What rectification you want? What
Lordship,
rectification you want?
Lordship, the name of the respondent has been wrongly submitted as,
Sukumar Bhattacharya.
yes, that is the incorrect name, Your Lordship.
What is the correct name?
Devopriyo Gupta, sir, Your Lordship. We are also mentioning upon notice, Your Lordship.
এইটাকে তাহলে ওই শুক্রবার না বৃহস্পতিবার আছে একটা সময় আছে না, দেখে নিও। Keep a watch on the list.
I will, Your Lordship.
Either it will appear on Thursday or it will appear on Friday.
I will.
Yes.
I'm grateful, Your Lordship.
Yes, we kept it, Mr. Banerjee. You, none of us in the judgment, earlier judgment of Justice Sen and Justice Kapoor, which was being relied upon, that was a judgment on concession. When I was reading the judgment, my brother was reading the judgment. It was not pointed out to us. Mr. Banerjee, kindly come to that judgment, and Mr. Das.
Yes. For it.
This order in that FMA 56.
My lord,
FMA 50.
Yes.
That is annexed also. Penultimate page, Mr. Banerjee.
Yes, my lord, I have a copy of the judgment.
Read the penultimate paragraph of the penultimate page.
Yes, learned has however submitted the petitioners have no objection in the event the lease period is reduced from 999 years to 99 years.
This you did not say.
No, that lease period was reduced. That was not.
No.
But the ratio that I'm relying on.
No. That we understand because do you agree to this or not? If you agree to this, it's okay.
999 to 99. It anyway the 99 years. Mine is anyways 99 years.
No, yours is 990 because it was under the old policy. In the new government policy, it has come to be. Yes, take this. Eta onake dao. Read 3:1. Have you found that paragraph?
Yes, Manoj, I have.
Checking it up.
No. Taking it up.
পরেরটাতে কোন পাতায় আছে একটু বল না
The
That
2012
judgment has been annexed.
policy
বলে
is
in
99 years.
in can 2 they have annexed
See that.
আমি দেখছি বলে
But here mine, I'll just indicate. না, appeal court এর judgment. Page 57 is the একটু দেখো এটা। এই জায়গাটা একটু দেখো। হ্যাঁ, এটা কোথায় কত নম্বর পাতা পেজই তো মিলবে না কিরকম এই যে এটা
They have annexed it in the
page 57 the period 999 is mine is 999 years.
yes.
Yeah. This was the new one is 99 years.
So we asked you that that 50 lakhs you
50
said.
lakhs, yes.
So we did not record that. We
Yes,
did
I
not
saw
keep
that
it
one.
on
I saw
record because of this reason. Because even if concession is recorded, then if they do not agree to it, naturally you will have to face
My
this one. It has whatever order has to be passed. It has to be the order of the court.
Yes.
We
Yes,
cannot
yes,
record.
yes.
Now, so far as if you say, Mr. Banerjee, this 999, 99, you are agreeable, then all right, this troubled us. That's why
No,
we did
this
not.
even I had not seen, Milord. This I had not seen.
And so
The
we,
ratio I thought
Are you agree for 99 years?
I will have to ask, This I can't. And I understand the predicament that your lordships are also in. The bench has been constituted just for me. But this
this was not pointed out to
and
us
900
because-
years I can't concede without taking
No, we cannot ask anybody to concede.
No, but I can.
Had it been pointed out to us, we could have asked
Yes,
that
yes.
question on that day.
Yes,
itself.
yes, absolutely.
That is why we consider. But what difference does it make, Mr. Banerjee?
900
Ideally
years.
should not. 100 years somebody lives.
900 years.
That is something, the age-old provision which was. If you say 99, you agree, we will consider that and we will deliver our judgment. আচ্ছা তাহলে বৃহস্পতিবার আমাদেরটা আছে তো হ্যাঁ
Brother, may I save this?
Come on
Thursday at 1 p.m.
what can be done
Or I can just inform to your lordship's officers.
No,
This
no,
is
no,
very
no, no,
difficult
no.
for your lordship to again come meet only
No,
for this.
I will be sitting with my brother on Thursday also.
Then I'll take instruction on that then.
Yes.
Yes,
It will appear under the heading to be mentioned.
Yes.
No, no, we are passing an order. Order. আসো, এরম লেখো যে the judgment
This is my application before you lordships.
Is your other side?
It's, I serve a notice on them. Let this stand over for the week. Because I don't.
2015
Yes.
se application.
Yes. A very
Paper
short
book file.
point is-
Paper book file.
No. But I've already annexed the writ petition almost. No. The writ petition is not. কোথায় আছে? The writ petition itself has been annexed, and there was no affidavits were called for. If your lordships,
Was it ever heard?
no, this was never heard. We tried our best, but it was not heard.
Why tried your
Possibly-
best? You must.
Sometimes your
You
lordships
are not
know better than
interested.
what happens sometimes. But Millard's, if your lordships direct Millard that I serve a copy, I have served a copy. If I give them notice, a very short point is involved. in this. I will not take much of your lordship's time. A very short point is in. It's only the interpretation of section 40 of the Act, where the order of dismissal couldn't have been passed under section 40.
But you have to serve, no? This has
We
never
did serve,
appeared.
but
Where is your service?
affidavit of service.
When did you serve?
2015 when this matter was.
Ashok? It is against an order of 2015.
Yes, 15.
2013 order.
Dismissal was
So
2013.
for year 2015, 10 বছর তো।
10 years.
You have already attained 43 years. 53 years. দেখে নেবেন।
No, the order of dismissal is without jurisdiction. That is my point.
Ashok, affidavit of service as filed be kept আগে যেটা বললাম, এটা
And for the petitioner led by Advocate Fitzgerald Sami Mellot, I'm praying for not today, ma'am.
why it has come for the first time?
Yes, ma'am.
You are appearing. Who is appearing? দেখি একটু ফাইলটা দাও। এগুলো কি মেনশন করেছিল কার্তিক? মেনশন করার পর লিস্টে দেওয়া হচ্ছে only to take time. We don't understand why this conduct. Have you served the stay application?
But I'm not instructed. I don't know, my lord. My senior is in Supreme Court for DA.
Uh-huh.
For DA matter, my senior is in Supreme Court, so I am instructed to make it not today.
Senior Supreme Court cases.
Oh, we are very happy to learn that your senior has been engaged. Firdos Samim. Oh. So he has gone to argue DA matter before Supreme Court. That is why you are praying adjournment.
Your Lordship, in this matter, Mr. Mr. Shomo Majumdar.
Don't pray for adjournment always. What?
Mr. Shomo Majumdar is appearing before
Let us
the.
take what is the matter about?
This is with regard to the pay scale of law assistants working in the district primary school council.
Come.
There was a direction to file a report. A committee was formed by this honorable court, and a report was submitted on behalf of that committee. They have filed their exception to that. Now, finally, the matter is required to be heard.
Lordship, Mr. Shomo Majumdar appearing before the writ petitioner respondent, Your Lordship, due to sudden demise of his father, he is not appearing to court.
Oh.
So I'm praying for an adjournment for 3 weeks, Your Lordship.
3 weeks.
Grateful.
Grateful, Your Lordship.
Grateful.
Why you appear? The last order
Lordship has given me liberty to file exception to the report filed by my learned senior.
the last order that I couldn't see a mistake. I appear on number 2 to 6, but it is recorded 2 to 9. In the first order, he rightly and my lord,
Lordship, I have also served a copy of on my learned friend,
only on
the exception to my report.
it is only on
Hey,
Friday.
let us hear him. Let us hear him.
He appears on 2 to 6.
Lordship would remember on the
By reason of a typographical error. Was the order impugned first?
262 of the stay
Where is the order impugned?
Lordship, it is annexed to the stay application, Lordship, at page 262. Lordship, on the first day also I had indicated, Lordship, my scope in this present appeal is limited only to the period which is admitted period of service. I am not seeking to enlarge the scope in the appeal, Lordship. Even in the before the trial court, Lordship.
Please let us understand what is the matter about. My brother was not there when the matter was heard. So you place the matter.
I'm so sorry. Lordship, the appellant herein.
Was there any affidavits exchange between the
Yes.
parties?
In the before the trial court, Lordship, not in the appeal. In the appeal court.
They have filed an exception.
Yeah, Lordship, to cut short the matter, Lordship was of the opinion, because all that I am seeking today is the between the admitted period of service, I am seeking my service benefits. Now, Lordship, because I had not challenged the entirety of the trial court's order. The trial court comes to a finding, however, the finding is limited in my appeal. My claims are only limited to the admitted period of service. There was several other writ petitions where I have challenged the suspension order. Initially, I was put on subsistence allowance. Thereafter I had prayed for regularization. I did not succeed in those writ petitions. Today, Lordship, in this appeal, the short question that falls for is what am I entitled to during
What did you challenge in the writ petition?
Lordship, here I have not got any of my service benefits which I had rendered during the admitted period of service. And that is why a report was called for. They had stated that there is nothing which is payable, to which I did not agree. Lordship had given me an opportunity to file an exception to the report. I have preferred an exception to the report. I have given them a copy only on Friday, Lordship. In the report, I have indicated, Lordship, what are the heads under which I am entitled to get.
So wait, let us go through the
Lordship, that is at page 11
wait,
of my.
please let us go through the order. Yes.
Yes.
What you are claiming?
Lordship, only the admitted period of service
From
from Lordship 1990 to 1995, 26/11/1990 to 19/10/1995. That is the admitted period of service, Lordship.
why it is 1910? It is said to be 31st of March 95. Second paragraph 3 last. Paragraph 3.
No, Lordship. Lordship, thereafter.
Contractual period had been extended till 31st March 90.
Lordship, it was till 1995, Lordship.
Which month?
November. Lordship, I'll just show the document and give details, Lordship. This is at page 237.
Page 237 is a read court order.
Yes, Lordship. This records that the subject matter of challenge is the order of suspension. This was till the date of my suspension. After that, I was put on suspension and it was extended without prejudice. The term.
This was 2000. Your suspension order was 20th
Dated
October.
20, yes.
20th October 2010.
1995.
95. And when was the suspension? What? It was revoked.
Lordship, what had happened was the suspension. Yes, Lordship, what they did not
Which
find.
period do you claim actual benefit?
26/11/1990.
26/11/1990.
This is at page 120.
Correct.
I'm sorry.
Till
19th October 1995.
19th October 1995.
Yes.
So where from you are getting this 19th of that is on
Prior-
the date the suspension order was issued.
Suspension was 20th.
20th.
I'm taking a day prior to that. This they cannot deny because I was in service even after
Now
that. I challenged.
what did the court direct?
The
Court
court,
did-
Lordship,
court did-
in my
huh?
writ petition, the scope was a little longer because
How you are aggrieved by this order?
Lordship, because it holds, my lord. It holds that I'm not entitled to anything. They have given me a provident fund of 28,000 without paying any interest. They have not shown any calculation. They
That
have
has
just,
been refused by this court.
my lord.
That has been refused by
Lordship, that has not been considered. The very basis of the calculation, Lordship, which I'm at least entitled to interest and other benefits, which is their part of the documents, Lordship. And which I have also annexed, Lordship. This is true for everyone.
Now you are widening the scope
No,
of
no,
your
my
argument.
lord. Lordship, I
So
stay
restrict
limited.
yourself to that.
Absolutely,
Now
Lordship.
what they have paid for which period?
Lordship, they have not paid for anything other than 28,000 and odd, which they say is whatever you were supposed to get as part of your PF completely, which could not have been.
That was the provident fund due.
My lord, after the period of contract ended, we were kept in service. Now we had preferred a writ petition for regularization of our which was not granted. Ultimately, initially there was a stay. Ultimately it was not granted. But it is undisputed that I had rendered till 1999. Undisputed. However, that period beyond 1995 is what they say, that since a suspension order was there, you were on subsistence. I am not even going to that disputed area because in the writ I had claimed till 1999. Now what I am claiming is I've shortened my scope, Lordship, in the appeal because these are admitted position that I'm only asking for my undisputed period of service. This I am entitled to because the appointment letters would also show what I am
Now
entitled.
what is their stand?
Their stand, Lordship, boldly they have not given any calculation. They have simply stated that you are not entitled to. That is why on the last occasion, my lord was pleased to give me an opportunity to come out with an exception. I have given an exception. I have done my calculation. Now let them refute to that because they would have some data. Last time they said that we do not have any data. All the employees are given a particular employee code. That would be there with them. The moment they enter that employee code, they would know how much.
Apart from that, we are please answer our question.
Fine.
From 1990 till 1995, during your engagement on contractual
Yes, ma'am.
basis, did you get any payment?
Yes,
What was the payment?
that was the basic that I was entitled to, basic
So
salary.
you show us from your engagement letter that they are bound to pay you
Yes, ma'am.
these benefits.
Yes. Yes, ma'am.
সাসপেনশনটাই তো হলো 16th October 1990 না মানে 20th October সাসপেনশন দেয়নি কারণ ডিসক্রিপশনটাই সেটা দেবে না বল। So this for this interim order, you received some payment during 94 till the order of dismissal of writ petition. You
That was
must
the
have received subsistence allowance. Very good.
Which
Show us that what is your
Yes.
entitlement and what
my
is
lord,
their
may
opposition.
kindly give me. Yes. My lord, may kindly take up page 137,
Page 137.
137 of my stay application. If these are the contractual services and these are the conditions. Your appointment will be for a period which was for a year-to-year basis, lordship, per month. In addition to your entitlement for dearness allowance, HRA, CCA applicable, you shall be eligible for earned leaves, casual leave, half-pay leave. Upon completion of year which may be computed, you shall be eligible for encashment of earned leaves.
Where do
Lordship,
you find
thereafter,
gratuity? Where do you find gratuity?
Lordship, I shall show from there.
I have show from page 137.
Lordship,
You
may
will be
kindly.
entitled to leave travel,
Yes.
disbursement of children education,
Yes.
CPF amount. You will be entitled TADA,
Yes.
LTC.
Lordship, there is a communication from their end.
We are asking you one thing to what we are asking. Then you argue.
I'm sorry, mother.
Is there any rider here as regards payment of gratuity? Yes, there is no provision.
Lordship, there is a communication from Macon which my client had received, and pursuant to that, I think they had also filled up this form which is at 176 for gratuity. Lordship. We shall just indicate. Oh.
You have
Yes.
not prayed for gratuity in your writ petition.
Lordship,
You have not prayed for gratuity in your writ petition.
I will not say that, Lordship, because it's not there. I've seen that. Lordship, at 201, page number 201, because I was not there at the writ stage, my lord, I'll be candid, Lordship. At 201, perhaps this is what prompted my clients to come up with the prayer for gratuity, Lordship. At 201 is a communication, Lordship, where they say, this is addressed to me, Lordship. We are enclosing a set of provident fund and gratuity settlement application which is to be filled up for our certification. This is perhaps the only document, Lordship. I absolutely understand, Lordship, which may have prompted. And since he may have applied, because he had applied for that form is also there, Lordship, which is also annexed to this petition at page 205,
So
application for.
Mr. Roy, was as regards your entitlement. So gratuity entitlement is not there in your service contract. It's a contractual engagement. So far as retrenchment, court held that this is not.
Retrenchment, I'm not.
Then, sir, what you are saying?
Lordship, the other which I have indicated, Lordship, may kindly take up page 11, man.
This you are indicating in reply. This was not your case in the writ petition. You must have shown the calculation as regards your dues in your writ petition. You are asking us now, Mr.
I
Roy,
completely understand.
when they have used an exception, you are coming out of
No,
the additional facts.
My lord, in before the writ court, because Lordship, what I see
You were
gather
not
from
there.
Lordship, what I gather from record is they also did not, even after using an affidavit in opposition, they did not come out with any calculation, my lord. All that I was asking today, Lordship.
There is no
there would be-
calculation according to them.
Lordship,
They
there
are
would be
saying,
some- Lordship, they had paid before the writ court, Lordship, a sum of 28,000 and all.
that is provident fund.
Lordship,
CPF.
that also has to be on the basis of certain calculation, my lord.
That was for you to seek appropriate instruction before filing the writ petition.
That I had received during the course of hearing.
You should have questioned it then. Show us anything, any entitlement on paper which they have not paid.
Lordship, Lordship had seen my contractual service. Lordship, I was entitled to
Leave and exception.
Yes,
Yes. This is of 1999. We are in 25.
No, it's of till the year 1995. I'm not going till 1999. From 1990 to 1995.
Yes.
There have been thereafter there have been series of litigation, Lordship, and writ petitions were pending for a long time. And this particular writ petition, Lordship, I think was also filed sometime in the year 2013. 2012, I'm sorry.
How can we help you, Mr. Rai? Show us some calculation, what they have said in their exception.
Lordship, these are simply bald denials. They have not even stated anything, my lord. In fact, they say leave salary appellant.
Wait.
I'm at page 5, my lord.
Why did you show us page 267? Earlier order we said
Yes,
as contribution towards family
Yes,
pension scheme.
Yes, madam.
Where
Those,
is that
those
for?
contributions were made by me,
For family pension scheme.
my lord.
Show us where is it? Page 267.
My lord, may kindly take up page 268, which I have marked. Lordship, it's written FPS.
Where?
F. Lordship, at page 268.
FPS.
Also, it is there. FPS.
FPS stands for
Family pension scheme.
FPS.
On that side, Lordship, it's
Yes.
written deduction. So these were deducted from my.
This is
Basic.
salary of which month?
This is salary of December 1991.
Where do we get that?
Lordship, at the left-hand column, Lordship. Month is written.
Left-hand column.
Left.
Month.
Month, December 91.
Very good.
Lordship, whatever little amount that I am entitled to, I have indicated also in my exception, Lordship. If Because if they're disputing it now,
Now, what they have said in their exception,
Well.
as regards family pension,
Lordship, pension they say. This is
The
at
report.
appearing at page 6, bottom of that page.
Yeah, just now. Where is the order of 26th February 2001? The suspension order?
Yes.
Suspension was set aside.
Yes.
And you were directed to pay the difference along with interest of 12%.
They were directed.
You got that amount.
No, Lordship, I did not get the entirety of it. That is why.
Mr. Roy, when you make a submission, you have to show your pleadings in the petition. If you don't have any pleadings into that effect, how can you ventilate your grievance? It is their contention that they have paid you. Where is this order of High Court order of 26th February 2001?
Lordship, this
Common
is at
judgment
page
was challenged and the
237.
judgment.
This is at page 237.
Oh, no.
Lordship, it says the respondent employee is directed to pay the petitioner difference between the emoluments to which the petitioners were entitled to and the subsistence allowance paid to them on and from the date of suspension until the. I'm reading for.
Yeah, just now.
I'm sorry, madam.
So did they pay you that up to 2000? They have said, though the writ court order was set aside in appeal, they have paid you the salary up to 25th June 1999.
Yes. That
and so far as the family pension, they say that was converted into contributory provident fund, and they have given the details to that effect.
Lordship, they have never shown, Lordship, this is my only case that they have never shown any calculation to that extent, Lordship, because I'm also.
So show from your writ petition any calculation. In appeal, we
in
cannot
the-
widen Mr.
No, no, my lord, I will not go to that extent, my lord.
Then, Mr. Roy,
because,
how
Lordship,
can we
I
help
had even on the first occasion, Lordship, I had indicated that my scope in appeal is extremely limited, my lord. I am entitled to interest. I'm sorry, my lord.
Final settlement of provident fund.
ওই স্যালারিটা দিয়েছি 99 যেটাতে not entitled. আপনি কোথায় আর সোফাটা পেয়েছেন সেটা আমরা ইপিএস Yes, show your calculation from your reply.
Lordship, that
So,
is at page
Mr.
11.
Roy, how much did you get from 95 to 99?
Lordship, that is also there, Lordship.
Page?
I'll just indicate. That is at page 214, my lord. They have paid to me. I have annexed it, Lordship. 43,000 and all. 43,102 rupees, Lordship.
This you have received.
This I have received, yes, Lordship. This was by way of a check, Lordship. The next page I have also have.
Very good. Now you show what calculation you are showing.
Lordship, that is at page 11, Lordship. That is at page 11 to my exception to the report.
Page 11 to your exception.
Which I have filed today, my lord.
Yes, which paragraph?
Lordship, page 11 of my.
Page 11.
I have made a chart, Lordship, because Lordship had indicated that you please make a chart of what you are asking for.
Achha, show that reflection of this in your writ petition. Show us anything about this in your writ petition. Mr. Roy, how can
Lordship, Lordship, my hands are tied, Lordship. I completely understand, Lordship. This was.
You can show us any document.
Lordship, this comes from the appointment, Lordship. I'm not trying to enlarge anything which is beyond that scope, Lordship. I completely understand, Lordship, what is troubling my lord.
সেটা টোটাল এক্সপ্রেশন এই যে পেনশন describe employment at Macon, non-pension type employee. Approval CPR. Macon would like to submit as a member of voluntary pension scheme. That upon increase of voluntary merge with and the contribution stands repeated. আচ্ছা এখানেও যে চার্টটা দিয়েছে সাপোর্টেও না সাপোর্টিং আচ্ছা 1 নম্বর 2 নম্বর 3 নম্বর চলে গেল নাও হোয়াট রিমেইনস ইজ লিভ স্যালারি লিভ স্যালারি 95 এর একটা টাকা বাকি আছে ফর সাপ্লিমেন্ট এখানে ক্যালকুলেশন কিছু দিতেও নেই।
Correct. Lordship, even at page 15, Lordship, my
15.
entitlements, yes, 15 of my exception, Lordship, I have given this,
That is your leave chart.
the
show us
entitlement.
This you want us to read that along with page 11, because you are saying leave salary for balance ECL has not been given. Mr. Roy, show us that any such calculation anywhere was shown. This is in
Lordship,
reply you are adding to this.
Lordship, Lordship, I have stated on the very first day.
তাহলে
Lordship,
কি করে আর help
no,
করবে?
Lordship, the thing is, Lordship, even if we were to calculate the principal of the provident fund, Lordship, and thereafter I was entitled to 12% of interest, even that is not coming, Lordship. Even that is not coming on the date of payment, Lordship. This they cannot run away from.
You accepted it.
No, Lordship.
28,000 you accepted. Court records.
Lordship, that in my humble submission, Lordship, I do not know, Lordship, but that couldn't have been an acceptance, Lordship. It couldn't have been an
Yes, what do
acceptance
you
without
say?
prejudice, Lordship.
Since I have not used any affidavit in the appeal, I have prepared a short list of that. May I submit to your lordship? And what my learned friend is saying, I will show each and everything has been paid.
Give a copy to him. Give a copy to your friend.
Yes.
This we find. A list of dates here.
Yes. Page 2.
ওনার আগে হয়েছিল কস্ট ওর এগেনস্ট, সেটা আবার অ্যাপিলে স্টে করে দিয়েছে। So after that order of payment of all dues with cost in 2001, you made a payment to them.
Yes, yes.
Now
To-
that ultimately that your appeal against that order was allowed,
Yes.
and they are
Set aside
they are
the-
setting,
Yes.
then did you recover the amount which you have paid?
Though liberty was given to us, but we did not.
Liberty was given.
Yes.
Show us that order.
Just a minute. Page 233.
Page 233.
231 to 233. Your lordship kindly straight by come to 233.
Two 33 is Ajoynath Rai order. Why you are saying appeal? The appeal order? No.
Ultimate. Respondent will be at liberty to
No,
pay.
that is order we are wanting to see 28th July 2003 order. This is what order? Which you are
This is
showing?
Lord. Writ petition was dismissed They have, my lord, made a writ application
Eh?
asking for regularization of their service. And, my lord, it was previous, initially, my lord, an interim order was done.
Good. This was dismissed.
Yes,
This was dismissed by an order of 24th June 1999.
yes. And
They are
20,
not asked.
in the list of dates, my lord, that is not annexed here.
Very good. Now, this was the writ petition claiming regularization.
Yes.
We are wanting to know where is the order dated 28th of July 2003, appeal court order against the order passed by the Reach Court directing payment with cost.
Yes.
Where is that order?
That order has not been annexed.
That has not been annexed.
But in my list of dates, my lord, I have mentioned.
Not an annexed. Where is the, what is that order of Justice Ghosh, Mr. Rai? You have annexed
Justice
one order,
Ghosh
na?
is at page 237, it starts.
Yes.
It was challenging my suspension.
Now, by this order, suspension was set aside.
Yes.
Eh?
Yes.
This is an order of 2001. আর এটার কত অজয়নাথ রায়ের অর্ডারটা কত? কত পেজ?
Lordship, the operative portion is at page 247.
247, the operative portion of 26th of February 2001. And 214, that compliance of that order. And ultimately, my lord, appeal court has set aside and dismissed their appeal, our appeal. Two 47. May I read, my lord?
Done now. Which page are you reading? Appeal court order.
Appeal court order, my lord, has not been annexed.
249.
না অ্যাপিল কোর্টের অর্ডারটাও আছে স্যার 249 থেকে আছে
251, it is annexed.
Yes,
19th
my
July,
lord.
19th July 2002.
My lord, the name of the petitioner would appear at page 249.
No, but they are
Serial
giving
number.
the date as 28th July 2000.
Yes.
Where from did you get that date? These are
No, this is the appeal, my lord, against
the regularization order.
Yes.
Oh, acha. This was also, appeal was disposed of when vacancy arises, may be given an opportunity.
Yes. My
Now
lord.
then, where this order has not been annexed. 28th July
No,
2003.
that has not been annexed.
Sorry, Mr. Rai.
Lordship, I was just request Lordship, even in the provident fund, Lordship, if Lordship is
Your
on
interest has been paid.
no Lordship.
I will show from the document. what my
Interest
li-
to Provident Fund.
Yes,
After that, it came to 28,000 and odd.
yes. I will
Was
show
that
to you the calculation. No, I have the document to show. Surely. I have made a copy for you. PPF 13,217.88 and interest on CPF 1255 of 7.70. CCF 13,217. I will show to you Lordship about leave salary also.
Lordship, in my humble submission, this would be the
My
principal.
learned friend client
This would be the principal, my lord, which I had also annexed at page
Yes, that you have in reply.
in the exception.
it is not
But Mr.
legible.
Rai, you have accepted that amount. Today, can you re-evaluate it?
Lordship, perhaps, Lordship, it's my humble submission, although I know, Lordship, there is not a line which records that. At least in the order, Lordship, it was placed during the course of hearing which was handed over. It must have been done by way of, Lordship, without prejudice to the rights of the petitioner to seek for
No,
rest.
not at the time of hearing. This was given to you on 2nd of February 2024.
Yes, that was,
Judgment was of March 24.
yes, Lordship,
2nd of 22nd it was given. You did not raise that issue.
Lordship, in my humble submission at the
The
advanced
present
stage of the hearing, Lordship, it couldn't have been without prejudice, my lord, because they have not admittedly, Lordship, from their documents, I'm able to show that I was entitled to 12% of interest. Lordship, may kindly see my page 13 of my, which that is their document, Lordship. The provident fund which I'm entitled to 12% of interest, Lordship. I'll show from their document, Lordship. At page 13, which I have annexed, my lord. Pardon me, it's not completely legible in that sense, Lordship. May kindly see from the bottom, Lordship, maybe the 5th line, interest calculated at 12% per annum.
Who will go into this calculation, Mr. Rai?
Lordship, they can easily calculate, Lordship.
They have disclosed their stand.
Lordship,
We cannot request them. We have to command them that you have not done.
Lordship, this is the
We are not at their beck and
no,
call.
no, my lord.
We are not at their beck and call.
Absolutely,
So the provident fund amount, whatever be the calculation that was given to you in course of when the writ petition was pending, judgment was delivered about a month thereafter. Any dispute you raised as regards that? The present appeal has been preferred. Challenging the rent towards the quarter.
Rent, Lordship, I have an argument to that. Lordship, what it was upon a twin sharing, Lordship.
Come with a
Which
better
they have
case,
not met.
Mr. Roy. Come with a better case.
I shall. I'm grateful, my lord. I'm grateful for this patient hearing, my lord. I'm grateful.
What is your full name, Mr. Roy?
Shokabdo Roy.
Huh?
Shokabdo Roy.
What is the meaning of Shokab?
Lordship, it's the calendar of Konishko. So the
Oh,
Saka era.
acha, acha, acha.
You're attending Mr. Dutt's chamber?
I'm sorry?
Are you attending Mr. Dutt's chamber?
Yes,
Maintain this demeanor.
I'm grateful.
Yes.
That is the lordship. But this is that matter, my lord, where the
We have 1,000 matters, Mr. Roy.
Lord,
That matter means
Lord,
which matter we do not know.
where my lord, my learned
So
friend, my
we
lord,
can dismiss. We do not know, we will dismiss.
but where my lord, my learned friend, my lord, pointed out that this writ petition was initially filed, my lord, under Group 5 cooperative.
Oh, acha, ki holo?
My lord, so my lord, I have checked. Yes, it is filed in Group 5.
We have been informed by the learned advocates appearing for the respective parties that the present appeal arises out of a writ petition.
To appear on behalf of the writ petitioners respondents.
Everybody is afraid of you. Nobody is opposing you.
Tonoy Chakraborty is appearing for the
সবাই চলে গেছে। পচা মামলা হবে বোধহয়।
The Section 5 application is pending.
How many days?
They say 190, I say some more, 220 days.
But you cannot sit in appeal over the stamp reporter. Oh, ঠিকই বলেছো তো 200 days.
And we have used the
Who is for
opposition.
the state?
Mr. Tonoy Chakraborty is appearing in the election
Shagnik Chatterjee. Oh,
for the respondents.
okay.
Writ petitioner respondent.
আর জয়ন্ত কোথায় গেল? আচ্ছা দেখ পোস্টার Shagnik Chatterjee for the respondents, তারপরে for the state. আরে কে appellant, কে respondent, কে দেখিয়ে দিতে পারো তো কারেকশন ফারেকশন।
By Honorable Justice Mantha, after going through a report filed by the state respondents. He directed regularization of the writ petitioners in that writ petition.
Oh, acha, acha. Yes, yes.
And on the basis of that order, this in my matter also,
বড় order করেছে। হ্যাঁ,
a
তারপরে
similar order was passed. Basing the whatever
so
was
the matter has to be heard, Mr. Jha.
yes. The only thing I am saying is that the reports and other things were not filed, and the adjudication was also not made in my writ petition. Only on the basis that a similar order has already been passed in a similar matter, this order was passed. I am only beseeching before your lordships that that appeal also has been
না,
filed
সে
by the
ঠিক
state.
আছে।
Both the
So
appeals have taken-
your service was regularized.
yes, direction was passed for regularization of service.
And that appeal is also pending before us.
That is also pending before your
So
lordship.
have we directed filing of paper books?
No, that is also at the same stage. Section 5 application is
number
pending. Yes, your lordship.
But I've been told Mr. Tonay Chakraborty is appearing on behalf of the state government, my lord. But he is on leg.
আচ্ছা ওই দুটো নাম্বারটা দাও।
Yes, your lordship. I'm indicating.
ওই ওইটাকে আর ওইটাকে এক সপ্তাহ বাদে রেখে।
হ্যাঁ।
Alright, come next Thursday.
Your lordship.
Your other matter will also come.
Lordship kindly directs this appeal also to be both the appeals to be heard together.
That is not before us. It will appear on the next day.
Lordship can direct this matter to appear with that, so that we can mention and bring both the appeals.
No, we are saying both these will appear next.
Well, your lordship direct, I will serve notice with regard to that matter. This cannot be heard separately. This has to be heard together.
But when we have made that matter returnable?
That was made returnable in February. Somehow it did not come.
See the order. We directed enlistment in combined list.
Yes, that was there.
Thereafter it came to supplementary. Jano?
I have to, because I am not the advocate on record.
So very good. We keep it next week.
Well,
if you don't oppose, we will consider the section 5.
Yes.
First, it has to be allowed.
Yes,
We'll allow the section 5, and then when we fix it up, you tell us that when that matter is fixed, so that we can tag both the.
Very well.
Yes, next.
Good.
12. Yes.
My lord,
I am for the responding.
my lord, Advocate Kakuli Somajpati appearing in the item number 12, 13, and 14 for the appellant. She has come to the court, but she leave the court due to some personal urgency. Kindly fix the matter on Friday or next week.
What is the matter about?
Before my lord takes up this matter, my lord, I just kindly, my lord, do not take me this, my lord. This series of matters were taken up together, my lord, by the honorable single bench. One of the matters, my lord, my learned senior friend Mr. Kollol Basu was appearing, my lord, for the petitioners, and thereafter, my lord, Mr. Basu was, my lord, being assisted by myself as well as my learned friend Mr. Atriyo Chakraborty. So, my lord, I thought, my lord, it is expedient. I just mentioned this to my lords, and these matters are all together, my lord, are taken up together. But they did not prefer an appeal against that order. But those all orders were, my lord, passed together.
Was one common order?
Not common order.
Separate
writ petitions, but all were taken up together. 1, 2, 3, 4, 5 this way. So, my lord, I just thought, my lord, I just informed you.
Separate orders were passed.
Yes.
And then in all the matters he is appearing.
No, my lord, in one of the matters. One of the matters, my lord.
So this will be heard analogously.
Yes, before the honorable single bench. They did not prefer any appeal against that order, but all these matters will be taken up together on 3rd of April all together.
On personal ground of one of us, bole, madam, then try before any other bench. And those matters, has not come up before us.
No.
My lord, appeal has been, my lord, preferred against 3 of the matters, against 3 of the writ applications. Mr. Chakraborty, my lord, is appearing in, my lord, in another matter.
Within those 3?
No. My lord, outside those 3. Same point is there, my lord. Same point was agitated.
On personal ground of one of us, bole amar naam diye, comma, the matter stands released from our list. Stop. Before any other bench.
Okay, ma'am.
Will she come tomorrow?
Oh, my lord. She will come on Friday.
So do you have any, this I cannot hear on personal ground. So it has, do you have any, I don't know whether your senior has any other choice or not. She also appeared. She was there in the trial court.
Yes, she was there. She was there, ma'am.
She is the chamber junior of Kakuli Samajpati.
So, madam, we are releasing the matter on personal ground. You take steps for assignment.
My lord.
Because they point out that in some matters we may have this objection.
My lord, my lord.
That's next. Yes.
Grateful.
ওনাদের নামগুলো দিয়ে দিও। Please give your names. You also give your.
You need to go to the.
15, my lord, I appear for the applicant.
15 also same.
No, 15
No.
is a different matter, my lord. So I appear for the applicant, my
My
lord.
lord, I'm for the respondent, my lord, the writ petitioner. My lord,
Let us hear him.
my lord, Mr. Parthagus is appearing in this matter, my
Call
lord.
Mr. Ghosh.
My lord, there is already a fixed matter in courtroom number 23, my lord.
Yes.
For that,
23 is a single court or a single bench or a division?
my lord, there are several original side matters, my lord.
Single bench.
Yes, my lord.
অরিন্দমের কাছে ask him to come. Yes.
Yeah.
Hey, wait.
মালিকের রোজগারটা
রোজগারটা You stay here. Where do you are going? Stay here.
Will it any of you have
Once we,
Please, your pardon.
once
আমি ছেড়ে দেবো আমি বলছি এমনি কি
what is this matter that এটা শুনেছিলাম second show cause disciplinary proceeding.
Yes, disciplinary proceedings, second so called, my lord. This is the second round of litigation, my lord. First round of litigation challenging the charge sheet. Writ petition dismissed, my lord. Writ petition disposed of without affording any relief to the writ petitioner, my lord, which was carried to appeal. Appeal dismissed, my lord. Thereafter, disciplinary proceedings concluded, my lord. Inquiry proceedings concluded, my lord. Report submitted. Now, thereafter, second show cause notice was issued. At that juncture, my lord, first they raised an ID, my lord, industrial dispute before the authority, my lord, and thereafter, my lord, they filed this writ petition. Now, in this writ petition, my lord,
No,
this order-
industrial dispute they raised. Then file the writ
they
petition.
filed this, my lord.
Hmm.
They raised the industrial dispute. They filed this writ petition also, my lord, after issuance of the second show cause notice, my lord, challenging the disciplinary proceedings and the second show cause notice.
So
And where, my lord, this order was passed.
this is a interim order.
This is an interim order. But what order has been passed? I
Proceed
have
on
been
the basis
restrained.
saying but no final decision taken.
I have been restrained, my lord, to take any final decision.
But have you? They must have action in the decide to proceed within then a fortnight. Did you proceed after this? With
No,
the
my lord,
second
we have
show
not
cause?
proceeded. We have not proceeded because we are restrained by this order, my lord. So we have not.
No. You have been said take up the order.
Yes,
If
my lord.
ECL decides to proceed on the basis of the second show cause notice, then a fortnight time should be given to the petitioner to file his response. This extension is given because the time to file reply against second order has expired.
Yes.
So you proceed now. You give
No,
him
my lord, we
opportunity.
cannot. My lord, we cannot. My lord, why, my lord? My lord, kindly see.
Why you cannot?
My lord, kindly come to page 281.
21 of
281 of the second volume, my lord.
281 of
Of
second
the
order.
stay application, my lord.
Order,
Order, my lord.
Order impute. Yes,
Order
show us,
impute.
tell
Yes,
us.
my lord. Here, my lord, it's first, second paragraph. After hearing the parties and considering the materials on record, I find that the matter requires to be heard after affording the respondent.
Which page you are reading?
281 second paragraph.
Third hearing. Yes, after hearing.
Yes, my lord. After hearing the parties and considering the materials on record, I find that the matter requests to be heard after affording the respondents an opportunity to disclose their stand on affidavit. At the same time, if no protection is granted to the petitioner, then the writ petitioner after completion of affidavits may be only of academic interest without serving any practical purpose. In the aforesaid facts and circumstances, let affidavit in opposition be filed by ECL by 28 February 2025. Reply thereto if any be filed by 17 March 2025. My lord, thereafter, my lord, if your lordship now skips one paragraph thereafter, my lord, there, page 282, it is made clear that ECL can proceed on the basis of the second show cause notice, but no final decision shall be either made and published or internally circulated amongst the officials of the ECL without express leave of this court. My lord, after issuance of second show cause notice, nothing remains excepting taking final decision. Except taking final decision whether to exonerate or to punish him as
Yes.
my lord proposed in the second show cause notice.
Yes.
So if I am restrained, my lord, I cannot, because there is a provision for appeal. There is a
No, Mr. Das. It is a question of prejudice.
my lord, then it
Question
is
of prejudice.
yes.
Your writ petition has been filed. The court says that second show cause notice, let him give the reply. You take a decision on the same, but
No,
don't
my
pass
lord,
the
no, my lord. I'm sorry, my lord. Please kindly, my lord, pardon me.
it is second show, but no final decision shall be either made or published on. So final decision which you will take, that you will keep in a sealed cover. Then you will place it at the time of hearing of the decision. এর জন্য কেউ মামলা করে নাকি?
No, my lord, kindly see. My lord, kindly see. No, my lord, kindly see. Decision shall be either made. So I cannot make the decision. My lord, kindly see the line. But no final decision shall be either made and published. So, my lord, either made and published. So I cannot
and published.
made and either made. my
Make
lord.
it, don't publish it.
So I am restrained, my lord, because after second show cause
We will
notice,
clarify. We will clarify.
nothing remains.
So you make the decision, don't publish it.
Very well.
So
My lord,
now this goes before the court.
Very well.
My lord,
And no final decision
Because
made. They made would
Either made and published or internal.
my lord, this appeal,
made or published হচ্ছে inextricably wrong.
Take it, can be taken, let them take it, but let it not be published.
and
my
my lord,
lord, my lord, kindly,
may I only pray, my lord, thing, if your lordships are clarifying, my lord, this, if there is a time bound, my lord, there is a, so that this matter writ petition can be disposed of within a time frame, my lord. Otherwise, my lord, this person will get superannuated.
When?
My lord, this year, my lord, he will get superannuated. This year only, he will get superannuated. And my lord, this is a case, my lord, it's a
December.
case of impersonation. And my lord, if your lordship kindly goes through the entire order, no reason, no cogent reason has been assigned. It's only recording of the submissions of both the parties.
আচ্ছা, তুমি কেমন বলছো? যে either they
Not published or internal. Then published, so action
can publish মানে hands and taken.
taken, but not.
Decisionটা যে নেবে, যে মেড কথাটা মানে হচ্ছে তো ডিসিশনটা নেবে। ও বলছে না, ও বলছে আমাকে, এটার মানে হচ্ছে যে
Because my lord, if your lordship is lordships are clarifying, my lord, then I have nothing to say in that event. But otherwise, my lord, if your lordship goes through the order, my lord,
why you are wanting a clarification, Mr. Das?
because I,
So let us read together.
yes, my lord, my lord.
It is made clear that ECL can proceed on the basis of the second show cause notice, but no final decision shall
be
be
made.
shall be
Made.
either
No, my lord, yes, shall be either made,
Either
made.
and published or internally circulated. So two options are there, made and published and internally circulated. You are debarred from these two.
Yes.
Is it your argument that by virtue of this order, I cannot take the decision also?
My lord, how can I make a final decision if
Then we cannot make it.
Mr. Das, consider this. This is what we were discussing. Is it not possible for you to interpret this way that the decision is made but not published? Neither internally.
that we can do, because for that we can, no, that we can do subject to the, provided your lordships clarify it, because otherwise, my lord, I'm stuck, my lord, here. Because I am not attacking the,
My lord,
एक minute, I'm बोलने को नहीं. I am not attacking the order by saying, my lord, that there is no cogent reason. It's only recording the submissions of the parties, because at least prima facie case is to be made out. That is not there in there. That does not reflect from the order, my lord. So that is not there, my lord. What is the case? What are his grounds, my lord? And that is to be distinguished, my lord. Those are not here, my lord, because it's an interim order, my lord. Most of the grounds he had taken already been decided by the Honorable Court in the first round of litigation. And others I can show that.
because clause 15.
Petition is not maintainable, matter is pending, and you are taking maintainability of appeal.
Mentally of this, my lord, appeal
You know?
that whether, my lord, in an interim order passed by the trial court can be appealed against. Because clause 15 says appeal in judgment, appeal. Well, I have this.
Has the effect of almost disposing of the main matter.
Yes.
That is the concept of clause 15.
Yes, clause 15. Now it has not been disposed of. They have the chance to argue on this point, and my lord, they have not filed the affidavit in time as was directed by the trial court. They have not filed the affidavit. Affidavit they should have filed in time.
So have you come up against this order before us?
No.
This is in your favor.
Yes.
So we are not disturbing you. What is your problem? The present appeal has been preferred, challenging an order dated 27 January.
So
That was not interfered?
Yes, not interfered. He carried the order to the appeal, my lord. Appellate bench, the honorable appellate bench dismissed the appeal. Those orders are here, my lord. Those are annexed here. Because his contention is, basic contention is that the charges are still. Those have already been decided.
Mr. Das, learned advocate appearing for the appellant
that word, my lord, why I'm troubling your lordship. Because if we cannot make the order, my lord, final decision, because after second show cause notice, nothing remains.
আচ্ছা এরম লেখো তাহলে ওই আগের প্যারাগ্রাফটা একটু পড়ো
It has further directed that if the appellants decided to proceed on the basis of the second sober notice, the writ petitioner may file its response.
না
Dismissed, my lord. Disposed of. Dismissed.
disposed of. We are clarifying.
Get.
Ultimately, you want.
The order is remain same, my lord.
Yeah.
I have prepared a lot of things, my lord, on the point of maintenance limit.
সেজন্য তো কষ্ট
Clause 15 and clause 15 will not. This is not the judgment and not appealable, my lord.
that you argue in a weighty case, not in this sort of.
My lord, that's why I have not.
That judgment.
Well, I have brought the, my lord, latest judgment. The judgment.
Court judgment.
Yes, I have just, my lord, I have brought that judgment.
Clause 15.
Yes.
Troilokanath or something.
No, this is the latest one, my lord. 2023.
No, 23. Parent order of this.
Parent order has been, my lord,
referred
referred.
to in our appellate side rules.
My lord, parent order has been referred here.
ওটা খুঁজে দেখেন
Para 22, my lord. Can you see para 22, my lord?
আমাদের appellate side রুলসটা ছিল প্যারা
22, my lord.
এই যে তুমি আর্গুমেন্ট করছিলে Chidambaram. Point,
Let us pay, clause 50, let us patent appeal.
ওইটাতে এই পয়েন্টটা ফুটছে না জাজমেন্টটা প্লেস হচ্ছে
Here also civil.
একটা স্পেশাল বেঞ্চ আছে আর একটা সুপ্রিম কোর্টের পুরনো আছে পাচ্ছে অ্যাপেলেট সাইড রুলসটা এখানে আছে এই বইটা এই কালো রঙের
Shah Babulal Khimji.
হ্যাঁ শাহবাবু
Shah Babulal.
originated from শাহবাবুলাল
That is already referred here, my lord. Tavo,
referred
Savo Khimji.
Khimji.
Khimji. Reported in 1981, my lord.
Yes, next.
My lord, I am appearing on behalf of the Appellant Life Insurance Corporation of India. My lord, affidavit of service.
Therefore, the repetition response.
Affidavit of service. My lord, being aggrieved and dissatisfied with the order passed by the Honorable Single Bench on 8th January 2025, we have preferred an appeal before the Honorable Court, my lord. My lord, the fact.
Yeah, give us 2 minutes.
My lord.
Okay, grounds of appeal.
My lord, the brief fact of the case is that the writ petitioner's husband
Expired on
was an
4th September
4th September
2023.
2023, my lord.
Your only
Thereafter-
ground is that the Union of India was not made a party. That's your only ground.
Not only that, my lord, the fact of the case is only the crack of the case is that after the date of the employee, the mother, my lord, my lord,
কি ভুলটা বলেছে?
my
What
lord,
is the wrong?
my lord, after the death of the employee, the mother of the deceased employee filed a civil suit against the wife and son before the latter civil judge senior division Chinsura Hooghly. And thereafter, the civil judge senior division has passed an order of administrative injunction. Kindly see, 72, page 72, my lord. Ordered portion, my lord. And before that, my lord, kindly trouble to turn page 70, the C schedule property, C schedule plaint. My lord, kindly trouble to turn 70 and 72, my lord.
That was subject matter of the suit.
Yes, death benefit of Gautam Mukherjee. My lord, got it, my lord. Death in Gautam Mukherjee due to the office of the Life Insurance Corporation of India. One, on account of gratuity, Gautam Mukherjee. Two, on account of leave encashment. And three, on account of GPAB. An account of GSLI. 5, an account of GTI. 6, an account of GIS. 7, an account of DCPS. And 8, all the amounts of LIC policy standing the name of the Gautam Mukherjee.
Who are the defendants 1 and 2?
Yes, my lord.
Wife filed
Yes,
it, mother-in-law.
Kindly travel to turn page 61, my lord.
Homa Mukherjee, Shogato Mukherjee. And pro forma is Aradhana.
Yes, and the divisional manager 3 and branch manager
Mother and son against the against mother-in-law.
Mother has filed a suit against the wife and wife of the
Wife and son have filed against the mother-in-law.
no, mother.
That's the reverse.
Shoma is this wife.
Shoma is wife of the
Mother-in-law
Shoma is wife
filed
and
against
Shagota
daughter-in-law and
Life Insurance Corporation of India also.
And who is Shagota?
Soma's son.
Soma's son. Employee sons of disease.
Shagoto.
Shagoto is a son of
Yes.
disease.
So the mother and son
Yes.
Mother and son.
has
So that's the opposite.
made the mother-in-law a party.
No.
Mother
Page
Just
60.
the opposite. Don't confuse us.
Aradhana Banerjee.
Shondha Mukherjee.
Gautam's wife and son have filed against Gautam's mother.
No. Oh, Aradhana
That's
is
the
wife
reverse.
of
That's the reverse.
Ravindra.
That's why it
তার মানে
is.
Aradhana
Well,
is
kindly-
the daughter of the deceased. Aradhana is
That's
the
kind.
daughter of the deceased.
Aradhana is the daughter of the mother-in-law. That's Shadhana.
My lord, I appear for the mother of the deceased, Sondha Mukherjee. I had filed the claim.
Mother of the you are Shoma.
Sondha
Shondha.
Mukherjee, my lord.
Shondha.
Mother of the deceased.
ও তা আমিও তো তাই দেখছি ও সন্ধ্যা হুই সন্ধ্যা
My lord, I am.
আরে ইউ আর নট
You are
সন্ধ্যা
My lord, the mother of the deceased.
আচ্ছা ভেরি গুড she is the mother, Homa is the wife,
Right.
and Shagata is the son.
Of the
And
deceased.
who is Aradhana?
Aradhana is the sister of Gautam Mukherjee.
তাই বলো sister of the deceased.
Sister of the deceased.
My lord, 3 and 4 is the life insurance branch manager and division manager.
You have been restrained from
Well, kindly travel to turn page
what is
72.
the date of this order?
No.
16th October 23.
Well, as per my instruction, suit is pending, my lord, but injunction order has been vacated on 5th August 2024, when the matter has been pending before the Lordship Honorable Single Bench, and they have suppressed the material fact before the Honorable Single Bench, and Honorable Single Bench has recorded the same. Kindly look into, my lord.
Now, when was it vacated?
5th August 2024.
That is the date of the order of the trial court.
That
5th August 24.
5th August, the order of injunction has been passed, my lord, on
Civil court passed an interim order on 16th October
2023, my lord.
When was it vacated?
Yes. 5th August 2024, my lord.
একটা ওকে দাও
একটাই কপি আছে
আচ্ছা ঠিক আছে। Okay.
It was vacated, tell us now.
আচ্ছা দিচ্ছি আমি দিচ্ছি।
Page 74.
না,
5th
এটা
August.
তো
5th August 2024 একটা আছে দাদা।
সেদিন কি বলছে ভেকেট?
ঠিক আছে।
সেদিনকেই ভেকেট করেছে। ও আচ্ছা।
And kindly see the order of the honorable single bench, page 74, my lord.
হ্যাঁ, this was not told to the court.
Yes, my lord. I have submitted.
Where do you have submitted?
No, this I have submitted on paragraph 2, paragraph 2 on 74 my page. On behalf of the LIC, it is submitted that the petitioner has suppressed the material fact as a proceeding concerning the terminal benefit of the deceased employee is pending before the district court at Hooghly, being initiated by the mother of the deceased employee. In the aforesaid facts and circumstances, the petitioner is directed to add her mother-in-law as party respondent to the writ petition and serve a copy of the writ petition on the added respondent, my lord. Not only that, my lord, on that day, the honorable single bench has passed an order to direct the life insurance company corporation to give the breakup, and on the very next day, we are ready to break up, my lord, on 4th September 2024, and the same has already been submitted before the bench, honorable single bench also. And
Break up on 4th September.
Yes, my lord. As per the direction of the honorable single bench,
Should come up with a breakup as to the details of the
Yes.
terminal. Acha. So you did that.
Yes, my lord. I have no latches, my lord, on the part of the Life Insurance Corporation of India. Not only that, my lord, at the time of hearing, I have already submitted before his lordship that there is a pending litigation, and his lordship and also recorded, my lord. Kindly travel to turn page 57, my lord.
4th September 2023. 4th September 2023.
File করার ছিল।
সুটটা ফাইল করেছে ওই ওর ভেতরে শিডিউলে নিয়েছে।
এটাও 23 23
ফাইল করেছে।
অর্ডারটা হচ্ছে 16th
অক্টোবর 23 থেকে 5th August 24 তাহলে ওই she was restrained from doing.
My lord, there is no prayer for interest in the writ petition also, my lord. My lord, kindly trouble to turn page 56, my lord.
Interest is accretion on capital. Court has proceeded on the basis good, bad, indifferent, money was with you.
My lord, there is injunction. There is injunction.
That we understand. It is not a penalty. Interest imposition is not a penalty.
My lord, we are ready to pay. My lord,
You are an authority. You are a
my lord, but there is injunction. How we will pay, my lord? There is injunction order.
No, we are not saying no wrong committed by you. We are not saying any wrong.
My lord.
It is not that interest is given for any wrong committed. Interest is given, which is a natural accretion on the capital. If I deposit 100 rupees, keep it in the bank for 1 month, I will get 12 rupees.
This is death come retirement benefit, my lord, and
Shiodam Giri, go through the judgment. Bhaskar Bhattacharya. Interest so you earned, na? You may have been restrained from giving it to the petitioner.
But there is an injunction order. That's why we are not paying, man. Otherwise, we will pay.
No, court has not held you guilty. That you should have. It is not like gratuity payment. Oh, retirement din dauni. You have illegally withheld. You pay interest. You pay.
My lord, we are ready to pay, but injunction order restrain me to pay the amount, my lord, to the. That's why, my lord. My lord, kindly appreciate, my lord, in this honorable
petition is still pending, na? Disposed of.
No, disposed. Writ petition is still disposed.
You have made the 1/3 payment.
No, my lord. We have preferred an appeal. That's why we are not paying. We're ready to pay, man. If interest will be expunged.
1/3 you pay and tell us, then we will consider. Give the amount. We were keeping it on Monday.
Monday, 1 week time. Allow me to 1 week time.
টাকাটা রিটেন করে he has earned something on that money that will also transfer.
কত হয়, কত টাকা ইন্টারেস্ট?
I don't know. I have to take instruction, my lord.
What is the principal?
Principal is
Principal
near
amount is-
near 1 crore.
1 crore.
1 crore।
These are all terminal benefits of the person and
সেটা
difficult.
তো গম্ভীর ভাবে বলতে হবে না, we know that।
Difficulty is this
My lord, my lord, honorable.
33 লক্ষ করে।
no, it won't be that huge, I hope, because
6% is 6 lakhs for 2 years. 12
but this was with them. They were enjoying their stuff.
My lord, they suppressed the material fact before his
What
lordship.
is the suppression?
they
I'm
are
unable to
critical
understand.
that-
This was
And
stated.
not only that, the answer,
The fact that you
there is
have-
injunction
No,
order.
this was being done on their behalf. And this was placed and thereafter this fund was distributed that the way it comes. And not only that, on the very day when this order was passed, this that
No,
particular
Mr. Banerjee, there was no embargo upon them to disburse. Embargo was court order. Court said, don't do it. Why did court say?
No,
Because
when-
you raised the dispute.
no, when this person got expired in 2023
September.
September, and when this particular writ petition was initiated,
Repeat.
suit was initiated even on October.
October
October.
2023, this suit
October.
has been filed. my lord.
Mr. Banerjee, had the suit not been there, then question of latches on their part.
I
will arise.
follow. I'm not just as if I adapt the sentence what she was acting on, that this particular person is not being put on guilty, that he's for not paying, but the fund was with them, they enjoyed their stuff. That is the reason I'm entitled to the minimum rate of interest which is applicable. This is a 6% interest. Even if it is put on the higher terminal benefits, would have been higher. The minimum, they are enjoying the funds. This is not that they are not enjoying the same.
My lord,
And after all,
he has
they are
not
LIC.
well, he has not made the prayer at the writ petition at the time of disposal. He has not made prayer in the writ petition for interest, my lord. Kindly appreciate, my lord. And not only that, my lord, kindly double to turn page 56, the last paragraph 3, my lord. In the instant case, the comma. May I
Page
permit to read
56.
page 56, my lord. In the instance case, the terminal benefits, if are treated as a part of the estate of the deceased employee, the same has to be divided into 3 parts. The widow to get 1/3 of the son, 1/3, and the mother, respondent number 4, 1/3. The son has not been made a party in the proceeding, my lord. LIC has provided computation of the terminal benefit receivable by legal heirs of the Gautam Mukherjee on his death in hardness. There is no dispute as to computation from the side of the petitioner widow and the mother of respondent, my lord. There is a dispute regarding the son, who is not a party to this proceeding. Initially, in the writ petition, an averment was made that the son is challenged. However, the averment has been expunged subsequently on the prayer of the petitioner. But averment have also been expunged without any affidavit, my lord. That's we have taken to the ground also, my lord. It will be open to the son, who, according to the petition, is a major, to approach the Life Insurance Corporation of India with the proper documentation for receiving his 1/3 share with accrued interest, if any. LIC, on being satisfied that the son is a major and is liable to look and is able to look after himself, shall part with the share of the son. The terminal benefits of the deceased employee were to be released within 1 month from his death. My lord, from his death, within 1 month. My lord, he has applied. My lord, kindly see. He has applied, my lord, page 53. He has applied 18th August, my lord, page 53, my lord. He has applied 18th October 2023, my lord. Total. He has applied before the Life Insurance Corporation on 18th October 2023. And thereafter, the suit has already been.
Not on that, sir. You satisfy us. There was no latches on your part. We are not saying that you are being. We will record that in our order, that there was no latches on your part. But fact remains that the money was with you, and it was not in the officer's hand. This money is in the bank. So this is the natural 6% interest usually which will occur.
My lord, one thing.
You show us any judgment that you show us any authority of law.
1 week, 1 week adjournment, my lord. I will.
আবার বলে action.
1 week adjournment, kindly, my lord. My lord, one thing, my lord, annexure B. This
You are not, we are wanting to know from you. We are not saying you are a bad man, you have denied payment. And you are also saying that I had no intention to deny. It was due to that interim order I couldn't pay. You are right. But the court interim order which has been passed, for that you could not pay, you are not guilty of any, you are not, your conduct is not, it is not that your conduct is bad. You want to give,
my
but
lord,
you
kindly
are
appreciate, my lord. We are ready to pay. Kindly expunge the order of interest, my lord. We are ready to pay, my lord.
ready,
Kindly
you
1 week
have
time,
to pay, na?
we'll ready to pay. 1 week time, we'll ready to pay, my lord. 1 week time, my lord.
When did they apply for the benefits? 18th October.
18 October. And thereafter suit has been filed, my lord.
Now, in fact, if you
Page 53, my lord. And order was date from the date of death. Honorable single just hold on from the date of death, interest will be calculated, my lord.
Oh, date of death.
Death, my lord.
Date of-
Honorable single just hold the date of death.
death.
And the
in fact, if your lordship be with me on the civil court order, lordship will find
and
it has
he
been
applied
mentioned
18
not to withdraw total amount. It has not. Yes, there lies the point.
So what would you be withdrawing?
Therefore, if it is being told not to withdraw the total,
Who was the nominee?
nominee was Shoma,
The wife.
wife. Even though,
And so just thinking aloud.
yes,
Other than Shoma, why would the others be entitled to any interest? Except for Shoma's share. Why would the others be entitled? You don't have a succession certificate yet.
yes.
no, now the fund is being distributed among. No, Shoma is
You would have understood there's a probate. There's a will, there's a probate. That's not the case.
no, if-
You don't have a succession certificate. Why then would you be entitled to interest?
no,
You don't have a right except for the nominee.
except for the nominee. The nominee is
But only the 1/3.
if that being so, nominee is entitled for the full.
Correct. That's for you. That's not LIC.
Nominee is entitled for the full.
That's not the.
Now we are not battling the issue with that regard. So we are
But he has
dividing
not
the
been a
center of
party to the mother-in-law in his writ petition, my lord. In a writ petition, he has not. Well, we are ready to pay. Kindly allow me 7 week time, 7 days time. I will ready to pay, my lord.
With interest.
Without interest, my lord. I'll kindly consider, my lord.
You satisfy us on this point.
Well, the court has passed the order from date of death, my lord. Kindly
Naturally, date of
death. And she applied my lord, 18, died on 3rd September 2023, applied on 18 October 2023.
Who had the money? Tell us.
LIC.
Was LIC. So LIC was.
LIC informed on. LIC has informed on 18 October 2023 that the employee was died. Employee died on 3rd September 2023.
So you earned interest on that. Suppose today I die, my son goes and tells you about 3 years later.
My lord, it has not been deposited in any scheme. It is not a FD. But it is not LIC policy. It is survival benefit of the death benefit, my lord. It is not a FD scheme, my lord. He also have not applied before the civil court for succession, my lord. Kindly appreciate, my lord. Proper court is civil court for.
আচ্ছা ঠিক আছে কালকে আসবে 7 days you will make the
7 days you require for the payment.
Come and tell us what will be the interest amount tomorrow.
Tomorrow is well, kindly after day of tomorrow, after day after Friday, my lord.
Then it will go next week.
Thursday. One day.
No, we are wanting to know. You take instruction. What is
day after tomorrow? Kindly fix day after tomorrow. I will take instruction. Day after tomorrow, my lord.
Day after tomorrow. No, you come with the calculation. Suppose total due is say 500 rupees. and the interest if calculated, it will come to this much of rupee. Let us know the computation. Then we will hear you and dispose.
Well,
Affidavit of service as filed.
maybe it is possible to date a fix out Friday, my lord. Therefore, I will take 2 days time, my lord.
Yeah. That would be
No,
Affidavit of service as
Friday
filed be kept
No,
on
fine.
record.
ঠিক আছে।
Are the learned advocates appearing for the respective parties? This is the matter for further consideration in the daily supplementary list of this court on 1st April.
My lord, to be mentioned. Fix to be mentioned. Matter will list to be mentioned. না ওখানে আবার আপনার তো
First April on a Monday. Tuesday. Oh, 7 days away. 7 days away.
সুবিধা হবে
No issue.
Acha, keep it on first now.
First, Lordship is fixing on the same
No,
status.
no, there are not much matters. Let us.
Oh, it will be on the higher.
next Tuesday. 1st April. Deviation.
Can you not come back on Thursday with the insta? Because one of us will be in circuit. So
Thursday.
next week we won't be there. Some new bench will be there.
Thursday.
You can get the instruction and argue before the next bench. You are keeping it on Thursday.
Thursday. 2 p.m. Thursday 2 p.m.
No, it will be in the list. Come, let us.
Thursday.
First.
We can keep it on first also, but we must tell you because
Yes.
tomorrow on Thursday, maybe next Tuesday, this bench may not. Another
Can you fix
bench.
the matter for Thursday? Well, I will.
Thursday.